talk about California Fraudulent Conveyance. Most states that adopted the 1984 Uniform Fraudulent Transfer Act, or UFTA, treat fraudulent transfer as a civil offense, including California under Code Section 3439. In addition, the Uniform Law Commission, perhaps in an effort to shed criminal undertones, even dropped the word fraudulent from the name of their recent revision, which is now referred to as the Uniform Voidable Transactions Act, or UVTA. I've been in the asset protection field for over 27 years, and we have established thousands of asset protection structures for many of our 65,000 plus clients. In 2011, California enacted Penal Codes 154 and 531 that added some potentially criminal elements to the fraudulent transfer topic. That being said, is it possible to protect your assets in California? Those who use these elements as fear tactics to squeeze a legal opponent, California statutes are not necessarily a cause for great alarm. Of course, no one is being advised to treat a fraudulent conveyance accusation lightly, but proving this claim in court is not as straightforward as it may seem. To begin with, California itself is quite specific and strict about the factors that constitute a voidable transfer. In addition, along with one or more of these factors, a creditor or plaintiff must prove that a debtor committed these acts for the sole purpose of getting out of paying his or her obligation to a creditor. Lastly, there simply is not enough case law history to go in with the California criminal courts. In fact, we didn't even find one person who had ever been convicted under these penal codes, certainly none of our clients seeking asset protection. Nonetheless, it is always advisable to transfer your assets before you face legal challenges. That said, however, if you have to move them in the middle of a lawsuit that's against you, don't fret, because remember, it's your creditor and his or her legal team that has to convince a judge that the fraudulent transfer claim against you is tenable. How to protect your assets in California worry-free. That said, what are some things you can do to protect your assets in California? There are tremendous and especially U.S. and especially international asset protection trusts that have powerful case law to back their effectiveness. When the trust owns an international LLC, you now have the remote control that you can, when needed, hand to your offshore law firm who acts as the trustee. Our offshore law firm can step in to protect you when needed. That way, the law firm is the one transferring the assets and not you. Now, what about real estate asset protection? For real estate, we record home equity lines of credit style mortgages or deeds of trust against the properties. Then, if needed, we have an international lender who purchases those loans and places the proceeds in an inaccessible account within your offshore trust company structure. How to not run afoul of the law. Okay, now that we know what to do, what are some of the things that can keep us out of hot water? Here are some key things in order to minimize your chances of running afoul of the law. Number one, set up an asset protection structure before you need it. The U.S. has 4.4% of the world's population, 80% of its attorneys, and 96% of its lawsuits. Lawsuits don't always tap you on the shoulder and tell you they are coming. The process server could be pulling up to your house at any minute. So be prepared. Put your assets into the right legal tools before you need it. Number two, state your intent wisely. There are many other reasons for setting up legal tools to secure your wealth other than asset protection. Use them. In other words, it might not be in your best interest to say, I set this trust and LLC up to protect my assets from you. When we set up a trust, we include estate planning provisions as well. I set this up for estate planning for my spouse and children is a very good reason. The U.S. is the most in-debt country in the world, so I set this up for offshore because I was concerned about our financial system. And here's another one. Cook Islands Trust can last indefinitely. Most U.S.-based trusts have a required expiration date. So you have the idea. Use other reasons besides asset protection to state your intent as to why you set up these structures. Number 3, know the law. California Penal Code 154 says that you need to have intent to defraud, hinder, or delay his or her creditors or their rights, claims, or demands. Thus, you have to prove intent. The other side has to prove intent. Likewise, Penal Code 531 says that one has to have intent to deceive and defraud others or to defeat, hinder, or delay creditors or others of their just debts, damages, or demands. And there's that word again, intent. Moreover, they have to prove intent beyond a reasonable doubt. If moving your own money to a secure structure is done for another reason, it is extremely difficult to prove intent at such a high level of proof, especially if you give the reason stated above. Knowing the law and following it can allow you to keep what's yours while taking the burden of fear off of your shoulders. And number 4, set up a trust. As indicated above, by setting up an international trust, you have a trustee, a law firm in place that can put the assets out of harm's way. That way, it is not you, but the trustee who is putting your assets beyond the reaches of your jurisdiction, who is moving the assets out of the reach of your opponents. And the trustee, being international, is not under your court's jurisdiction. If you need more information about protecting your assets from lawsuits, give us a call at 1-800-830-1055 or visit assetprotectionplanners.com. Thank you.